Okay, good afternoon, everyone. Today it is my pleasure to introduce Samuel Dahan, who is an associate professor of law at Queen's University and visiting professor at Cornell Law School, where he directs the Conflicts Analytics Lab, CAL. Samuel's research focuses on legal AI, dispute resolution, and access to justice, with an emphasis on human-centered and open source AI designs. He leads Open Justice, a no-code platform enabling layers to encode legal reasoning into AI systems, and collaborates with courts, legal aid organizations, and law firms in Canada, the US, and Europe. Sam's work is supported by SSHRC, NSERC, and the Law Foundation of Ontario. Dr. Dahan, we are so happy to have you here and ready for your talk on embedding legal reasoning into AI systems, open source approach to high stakes decision making.
Very nice. Thank you so much, Calvin, for having me. Very grateful to answer for supporting that project. So it's a great opportunity. We actually just received the funding, but we started a few months ago. So I changed the title a little bit. I mean, so because I was planning to talk about reasoning, which is still the main focus and the topic, but I thought it would be better to focus the um, on the objectives. So really, we think that embedding reasoning data is going to help us to achieve more reliability and more programmability. And I'll tell you why this is so important for law. So let me just, I mean, I don't know how many of you are familiar with the legal context. So I'm just going to give you a bit of a rundown of what's going on in law in general, the justice context, and what's been happening so far. So, I mean, there is a bigger picture, and that's been an argument, a socio-economic context that a lot of people have been discussing over the last few, I guess, almost decades now. So it's what we call the justice gap. So there is about 55 billion people that face barriers to justice worldwide. Does it mean? I mean, it means they have no access to any kind of legal help if they were confronted to a legal issue. And so if we look at Canada a little bit, it's not better. It's actually in some ways worse. So 70% of Canadians would get no legal help for serious civil issues. Okay. So recent data also we don't have similar evidence in the US is that was a study that came out last year, organized by the conducted by the Legal Service Corporation, and it showed that more than 50% of eligible clients were turned away by legal aid organizations. So just there's something really important here is eligible client. That means that people who don't have the means, they qualify to for legal aid. That's a very low threshold. Like most people don't qualify. Even the people who qualify, they just can't get access, not because legal aid organizations don't want to help, it's because mostly there's not enough resources. Okay, so that's the bigger picture. And in this background, people have been saying, okay, so then technology, I mean, every time there is a new tech wave, so that could be the web, that could be the app in the 2010s, then in 2015, the first wave of machine learning a breakthrough, and then now the GPT era. Many people tend to become overnight convert, and they say, okay, that's going to be fixing the access to justice problem. Okay, so then we end up pouring a lot of money into AI, and now obviously that's not only true in law. So there's a lot of, I mean, there are some predictions. Obviously, I mean, this is a lot of speculation. I mean, some people say it's going to be up to 60 billion investment in by 2032. I kind of believe it. I mean, there are already some companies that have already raised. I mean, I'm talking about legal tech companies that have already raised almost a billion, reaching incredible skyrocketing valuation. Okay, so you could say it's a great. I mean, it's a good thing. You could argue for the economy. Some of them are Canadian, some of them are not Canadian. I mean, and more if you look at it more. So if you look at the granular data, that's where it becomes a little bit more interesting. So 4 billion is in for legal AI transaction, about 1.4 billion already for in-house teams, but there's very little actually for the rest of the community. So meaning legal aid, solo practitioners. I mean customer facing apps. I mean, these are actually very hard. It's very hard to fundraise for these companies. Various reason is like it's just very hard to make a business out of it. I mean, people are just stuck with GPT and they go to court and they cite hallucinated cases. And you probably have heard the news. I mean, it's not getting better. So I mean, so I come from that perspective, which is that legal tech and legal AI haven't really moved the needle for several reasons. I mean, the first reason is that I do believe, and I think it's backed up by empirical evidence that a broken institutional framework, or in that case, a broken justice system, is not going to get fixed with tech. I mean, tech doesn't fix structural problems. It can really help to, cut costs. Sometimes it actually exacerbate problems. Okay. So a second problem that's also kind of common in tech in general and also in law is that it's becoming a bit of a winner takes all legal tech. So for example, there's about I don't know, a little bit more than 5,000 lawyers that work at very top firm and about 150,000 lawyers across Canada. So, and recent studies that most lawyers actually get access to very limited, high quality AI tool. So a lot of the investment is really concentrated around a couple of firms, which is fine, and I think it's great. I mean, and this should be applauded. I mean, I've been in the space. So the Cal, our lab, that does legal AI, was established in 2017. I've tried to work with a lot of firms, and it's only since 2022, essentially GPT, that a lot of firms that were not really familiar with tech decided, okay, that's great. Like, let's just get to work, which was not really the case before. So that thing that should be applauded. The problem is that it's not great for a lot of other firms that don't really have the resources to build or even like to access decent quality legal AI, because some of the fees are like we're talking about a couple of $1,000s per user per month. That's insane amount of money. So a lot of firms can really. So then another problem is really the reliability on of these tools. Even if they're very expensive, many of these are not reliable. So that leads to my research. The research motivation behind this project is how do we build legal AI that is reliable and adaptable. Really, these are like the two big questions I want to tell you. And why are these really important? So the first question is adaptable. I mean, programmable. Why is that interesting in law? I mean, like we should be able to access the same. We should all be. I mean, there's a principle in Canada and many systems that abide by the rule of law, which is that we should all be treated equally before the law. But the reality of law is that that's not really what happens. So this is what I call a representativeness problem. So legal work breaks down in several ways. I mean, so a dispute is resolved through court. I mean, it can be resolved through court, but the reality of lawyering is that 90% of the cases are settled. So that data never becomes public, and that data is actually essential to improve decision making. So if you look at historical data, I mean, it obviously is one way to improve your decision making process. So if we build an AI that's only trained on public case law, which is already a good thing, okay, having access, transparency of justice is very important, and so on, but the reality of court, and I think a lot of people who are not in law don't realize that, is that people don't go to court unless they really have a strong case. I mean, not always. There are a few anomalies. So you take the example of employment termination or someone fighting their employment contract. I mean, the contracts that get litigated are the borderline contracts. So they're not really reflecting really what happens in private 90% of the time. So what we do now is that we're building AI that are trained on, I would argue, an anomalies, so which is like the tip of the iceberg. And that the majority is not really represented. Okay. So the second problem is, and that's true for, and that's the fits very well with this responsible AI framing here for this talk is the reliability question. For high stakes decision like law, it is obviously very problematic because the state of performance is still pretty bad. So the average error rate is still around 60%. And we're not talking only about ChatGPT. So there are a lot of issues coming with ChatGPT. You may have heard, I mentioned earlier people that use GPT to go to court and then they end up citing hallucinated cases and even lawyers. So, for example, this fellow French colleague, he compiled this interesting database of all the hallucinated cases that have been caught by courts. Obviously, there are more. We're close to 1,000 already, and I'm sure it's going to get it's going to keep growing. Okay. So that's for people using GPT, but there's a bigger problem. I mean, this study that came out last year by a group of empiricists at Stanford, it suggests that the error rate for one of the top data vendor for their RAG system is still very high. So we're talking about, I mean, it's hard to say in terms of hallucinations. We're talking about between 20 and 35%, but there are a lot of also all other types of errors. So for example, counterfactual biases, some people are like, which is slightly different from sycophancy, but they're kind of overlap. So for example, you ask a question, I mean, you probably have seen that before already in GPT in general, like it tends to agree with you, but in law it's more problematic. If you say, for example, did Justice Ginsburg dissent on the Obergefell case, which is, for example, the same-sex marriage, the AI will suspect that you already have the answer, and it will say, okay, yeah, that's very likely, and then it will give you a dissenting opinion. But the reality of this case is that she actually was part of the majority. Okay, so you realize that a lot of the tasks, the use cases that lawyers do is research. So a lot of the time, I mean, when you know already very well the answer, that's a different question. But when you don't know, and a lot of people are doing research now on GPT and legal research, and that's causing a lot of problem given the the high level of hallucination rate. And that raises a lot of questions, mostly for junior lawyers and non-lawyers. Obviously, there's a lot of things that it can do very well. It can summarize very well, it can rewrite. We all know that. But the reality of law is that there's a lot of other tasks that are delving in the realm of the unknown. And as soon as there is the unknown, it breaks. Okay, when it comes to intake, interaction with clients ask a lot of stupid questions. No, makes sense. They don't know the law. And they think they have a criminal law problem. They actually might have an employment law problem. Okay. So issue spotting might be a bit of an issue. Exceptions, risk assessment, multiplicity also, having the ability to say, yes, okay, for that problem, a court says X, but a few other courts actually have said Y on the same problem. So it doesn't mean that there is an actual universal truth. It means that there could be multiple answer. So AI works very well when the reasoning is already in the prompt, but when the reasoning has to be inferred or has to be retrieved, it's where it's becoming really a little bit more problematic. So our assumption as to what are the root cause or the root causes of that problem. I think the main issue is that we're treating law as text and as text to predict instead of reasoning to decipher or to retrieve or to infer. And embeddings are very powerful. They encode meaning, but they don't encode the process or judgment or institutional logic. Okay, so I told you, so there are two main problems, if I may recap. One is a representativeness of the data. It's a lot of the data that is used to train these models, or actually we don't even train. There's no such a thing as a language model for law. We tried, we built a small language model, but it wasn't very good. I mean, some even people argue that it wouldn't make sense to train a language model for law because it wouldn't work because it's evolving all the time. But that's a different debate. So a lot of people are using the data that's available to add a RAG or to add an MCP or a web search engine on top of legal data. Okay. So but the problem is that it's not really representative of how law is practiced. And the other problem is that it still makes too many mistakes, and it's a high stake area. We can't really afford to make that kind of mistakes, and it's already causing a lot of problem in legal area. So the main focus has been really so far is that, oh yeah, but when GPT-4 is going to come out, it's going to be better. Okay, when GPT-5 is going to come out, it's going to be better. Reality hasn't. Actually, it's getting worse. The hallucinations are getting worse, and the error, the sequency is getting worse. And now what we're seeing is a proliferation of agents, but more at the level of deployment. A lot of applications are getting built into law firms, courts, and legal aid infrastructure. So, for example, a lot of agents now are being deployed through calendar invite, through intake process, and through word plugins and all that. So, if you think about the underlying performance of the model, what I'm trying to say now, this is really problematic because we're creating an ecosystem of agents that are making a lot of mistakes, and they're sharing that knowledge with each other, and they're interacting with clients, they're creating interaction channels with lawyers, but we haven't really fixed the real underlying problem. So and now with you've probably seen also this hype around vibe coding, this idea that humans can build apps with no code. Great idea. I mean, although there are a lot of scalability issues, but if we're thinking about deploying, integrating these tools, if we don't really fix the underlying problem of performance, I'm not sure we are good. Definitely, we're not going to solve the access to justice problem. I mean, in fact, actually, we might make things worse. So, what is the real next frontier? What are research and lawyers are exploring to fix some of these problems? So, what I'm saying is, where this is heading is can we integrate human reasoning into AI? There are probably various ways to build legal AI now, and there are various ways to deploy reasoning. So so let me be clear about one thing is what I'm not saying. So what I'm not saying is that we should be just throwing everything away, throwing the baby out with the bathwater in it. And we're not rejecting foundational models. I mean, for one reason is that no university today, I mean, has the resources to build a foundation model, which is one of the sad reality of research today. And a lot of foundational models are really, I mean, there are new infrastructure coming. I mean, there's Lacune, there are Sutton, there are many people working on new infrastructure. There's RAG that has showed some real promises, so retrieval augmented generation. And what we're adding here in this stack is actually I should reverse that triangle. So what I think is important is that we keep thinking data is key to success. So we've been adding a lot of legal data to these models. We've been adding a lot of these legal data to RAG and then that to MCP and so on. But we realize that the performance hasn't really improved that much. Okay. So it's not really about adding more legal data. It's about how you structure that data and how do you build a data infrastructure that lets humans instill reasoning into that model. So it's almost, I mean, I like it might be not a very, it's not the project is actually not as sexy as I thought it was because it's more of a data problem rather than an AI problem. So when we started on this project, we say, okay, if we train a language model for law, then that's going to be much better. And then if we at least fine tune a model for law, which we did, it's going to get better. Actually, our fine tuning results were inferior to GPT generic, GPT-4. Okay. And now the idea is a little bit different. So I want to spend a little bit more time thinking about how this actually works. So what do we mean by co-creation and knowledge integration? So we say that, I mean, I've been saying that legal AI fails not because it lacks access to text, but because it lacks access to reasoning, especially the kind of reasoning layer lawyers use in real practice. As I said before, a lot of that knowledge is tacit, and a lot of that knowledge is in text, is in private data. So just to give you a bit of an example, so if I give you a textbook and you're a very smart person, you have a photographic memory, it doesn't mean you're gonna know how to be a lawyer. There's a lot of knowledge that's tacit and that's about processes, about priorities that needs to be integrated. I'm not saying it's impossible. I'm just saying that there's a little bit more work than just dumping a lot of data into the model. So the way what we're trying, so how these reasoning flows actually work, it's essentially a no-code interface for lawyers to inspect and determine or help a language model, I should say, to go through the data that's already in most of the models or most of our open source of this open source platform. Okay. So, for example, how do you start? Which jurisdiction are we talking about? How do you apply a statutory test? How do you branch a problem depending on factual uncertainty? I mean, how do you make surface relevant negotiation ranges? How do you trigger escalation when risk is too high? So these things are things that are very hard to infer or to decipher if you really don't know them, if you don't learn them. So good news and bad news. The good news is that the results are actually pretty good. So it shows that with very first prototype, the error rates has gone down dramatically on a few problems. Good news as well is that you don't need to be a computer scientist to fine-tune a model now. You can really go through these interfaces and integrate that knowledge and execute it and deploy it. Okay. Bad news is that it's actually not that simple. It takes a bit of time. It requires a bit of training to do that. Okay. I mean, so now we're testing this in two main um, areas, the two use cases. The first one is legal aid, because we think high volume, like for example, Pro Bono Ontario, they're dealing with almost 3,000 phone calls per week. They have a really a busy hotline, and we're trying to see if it's possible to help them to process more cases and to serve, better their client through that intake process. So the idea really here is to work with them and integrate that knowledge that a lawyer would learn as they practice. So, for example, what kind of question do you ask a client? What do you not answer? And then you need to have a two-sided system that has the ability to provide a decent answer to a client, but not legal advice because it's making too many mistakes, and also a machine is not supposed to be giving legal advice. And at the same time, having the ability to pass along that knowledge to lawyers. So obviously also we're trying to work with firms to validate also how this works in practice, especially firms have a lot of internal knowledge. So for example, we're looking at employment negotiation and that firm is helping us to learn the last decades of employment negotiation and realize there's really a lot of interesting output. I mean, if let's say a court says that you uh, can make $10,000 with this case. But if the last negotiation patterns show that you can only get $7,000, I mean, it's really making a real compelling argument that you might not want to be going to court because you know that you can negotiate for much less. Okay. So all this is interesting, but the concluding question for all of us now is like, okay, how do you go from there? So yes, it's good, it's interesting to collaborate with firms, but there's also a risk that that knowledge might be sealed into a bucket and then eventually might not be really useful to the rest of the legal community. So we're really looking at two things. So first one is building a public infrastructure, an open source infrastructure for integrating that knowledge and making sure it's still part of some kind of a commons. So the notion of open source, I mean, I'm sure if you guys are here today, it's because probably you know the concept of open source because you're a scientist, but the concept of open source is kind of unknown in law, or at least many of the projects that have been tried in the past have failed. So I'm almost turning myself into a evangelist and trying to convince lawyers that open source is a good thing. You can still make money. It's not only, data that's stolen by China. So the concept of open source has been very old, and there are a lot of successful projects. I mean, for example, 70% of the apps that we use today rely on open source. And this idea that lawyers can come to this platform or this infrastructure that takes the form of a platform and integrate their knowledge, recycle it maybe, and deploy this through their firm or through their own practice and share it with other people. So I think this is an idea that is a little bit a hard sell. Okay. So we've been fairly successful with this endeavor in the academic world, in the non-for-profit world. There is definitely an incentive for law students, junior lawyers, to build that kind of knowledge, especially since 90% of lawyers are solo practitioners. But I have to admit, it's a very upstream project. I mean, in the sense that where we're looking at the quality of the output. We're not really helping lawyers to deploy apps and integrate this into their system because that's not really our skill set. So we're hoping that as firms are getting better at building their AI infrastructure, they might also be started to think about how do I make a contribution besides, designing or plugging, really, which is really essentially a UI problem. So I think they need to realize that they could shine with this idea of, okay, I need to build, how do I make my output much more reliable? How do I teach my AI to build knowledge instead of just going to GPT and create a GPT that's completely random and doesn't really yield good results? So that still raises a lot of questions. So we're still debating what are the governance principles we should implement. We've got about 1,000 contributors now in this platform across mostly Canada, the US, and Europe, mostly France and Switzerland, because we've got a lot of strong collaborators there. But it raises a lot of questions also whether lawyers are going to be really interested in building that kind of stuff because this is obviously uh, um, a foreign question for lawyers. So that's really where we are today. Um, I think I should stop here. I mean, I tried to give you a bit of a very high level rundown of this project. I mean, and if you have any questions, I think it might be good for us to take some time to talk about it a little bit.
Thank you very much, Samuel. I'm sure the room is going to have some questions,
I
and
have
maybe
a
I can just open up. Yeah, please.
Hi, thank you very much for a great presentation. So you show some stats that AIs usually do hallucination in legal cases. Is there any publicly available benchmark or data set for finding out the hallucination in them? And also, have you tested new very large language models? Because they seem to generate kind of less hallucinated data. I mean, the stats you show, is it based on which kind of LMs that generate hallucination?
So I think I understood your first question, but I need to. I'd like you to. I'll ask you a clarification question on your second question. On the first question on benchmarks regarding performance of LLMs applied to law, there are tons of stuff now. So I can share with you. I mean, offline if you want. There's the one thing called the Stanford study. There's a study also that came out called GPT. So this one is more really about the human AI interaction. It shows that lawyers are performing better. There's a study that came out of ETH in Zurich saying like that for senior lawyers actually Using language models is making senior lawyers slower and perform less. But when it comes to actual benchmarking of error rates, there are tons of benchmarks here. It's been well documented now.
Great, thank you. And for LLMs that has been tested, we know there are huge difference between different kind of the performance of different LLMs. Some kind of later one has a better one. Has this studies kind of covered different kind of LLMs?
Yes, yes, they have. Yeah, yeah. They don't work only with one, and they work with all LLMs. We've done our publications, but obviously we're not like these benchmark. But obviously we're not the only ones. They cover Claude. I think Claude is right now and Gemini are the highest performing for law and citations. Okay. But the error rate is still pretty high. And then a lot of them have also tested, these models in the context with RAG, and it's still the error rate is still very high.
Thank you.
You're welcome. Jeff, yes?
Yeah, so the thing that interests me a lot about what you were talking about was the idea of tacit knowledge and the role that that plays in performance or lack thereof. And specifically, you were talking about settlements, which don't show up in the record. It kind of makes me think back to the days of expert systems where there was
Yeah.
this concept of knowledge engineering.
Yeah,
Because it seems like even if you were to get the law firms to describe the outcomes in settlements, you still wouldn't necessarily know what the factors
correct.
were that were involved. So it seems like there's a knowledge engineering component to
Yeah,
determine what those factors are. And then ideally, you would have these law firms recording what those were. And then if they couldn't make it public, but they had internal databases of settlement cases and what those different factors were, they could then process that internally, perhaps, using AI to come up with a more procedural kind of approach to if, something closer to an expert system, if this and this and this are true,
yeah.
then et cetera. Is anybody
Yeah,
trying
so
that?
so that's what we're trying with a lot of the firms. So first, regarding your first comment, I mean it's a very interesting hard truth that we are realizing now. So for example, let's say one legal problem or dispute, let's say termination, because I think employment termination, it's a problem that everybody understands. So the courts, factors are known, they're public, it's established by the Canadian Supreme Court, okay? But then when you settle an employment dispute, there are a lot of factors that are relevant, but they're not legally relevant. So it's almost like you can't train the same model. You can't on the because they're not really exactly the same uh, problems you're solving. So, for example, you settle something, let's say a letter of apology is going to be very important. The courts don't give a damn about that. So these are relevant factor for a settlement. So that's one thing. So that's what we're trying to now. But now the problem is that a lot of that knowledge is not really structured, or if it's not even anywhere. So what we end up doing is our researchers are working with firms. They are like, it's almost like a lot of idiosyncratic factors, a lot of discussion. It's a very empirical process of evaluation and interview, because they can't just give you the data and say, okay, and then you merge the data and say with the legal data and say, okay, that's exactly that. These are perfectly aligned. They're not. So it's a lot of knowledge. I think you're right. It's a very good, I like this term. It's a big knowledge engineering problem where you need lawyer expert, domain expert, which is good a lot, which is good now with this no code system. You need knowledge expert, domain expert to sit down and say, okay, how do I make sense of that data? It's really more about deciphering the data, because now we know that dumping more data, unstructured data into the text is not going to get us better results. So yeah, there is a bit of this expert system, era vibe that kind of coming back. But the idea is what do you integrate into this expert system, and how do you make this expert system a little bit more dynamic? So in the way we built this system is that with different mini infrastructure, or what we call nodes, that are supposedly reflecting how a lawyer thinks. And it could be very different from one area to another. So, for example, termination is very different from insurance. For example, for insurance, we had to create nodes that have a computer vision dimension because there's a lot of imaging. When you add, like, let's say you talk to, product liability, you have to assess how, what is the value of the damage. But this is, I think you're right. I think this is a knowledge engineering problem.
Seems like there's a sales and negotiation component because you're selling a settlement essentially to a
Correct. Yeah,
client.
sure.
And I wonder if Salesforce has their Einstein system for doing sales. I wonder if there would be something you could learn from that.
That would be interesting. Yeah, I think a few people have been working. I think Facebook has published a few paper on Meta, a few on chatbot negotiation and sales. I think I'm working on a project with the European Commission on trade negotiation. But I think the real problem is really sitting down on integrating reliable data. And most of the problems that we've tried to solve on dispute resolution, there's also another problem of precedent priority. So in law, it's very simple. You said, okay, yes, even if you don't agree with that decision, if it's a court of appeal, that has authority. If I have 10 negotiation outcomes and I don't know exactly which one is best, how do you determine which one is actually better? So I think for the model, it's very hard. And humans don't even agree on which one is the better outcome. So I mean, you could have a simplistic approach. Okay, yeah, more money for me is better. Okay, but sometimes it's a little bit more complex than that. So I think there's also an evaluation component that makes it very, very difficult.
Thanks.
Samuel, you touched on it a little bit, but I'm wondering if you could offer us maybe an optimistic and then also a cautious take on the futures of all this.
So I mean, I can offer optimistic take on how the products are going to grow, and it's hard for me to talk. I mean, I can also talk about the future of the profession. I think I tend to be very optimistic. So in terms of the product, I think the only thing that concerns me is the risk of winner takes all approach. I think that's a little bit concerning, okay? But I don't see where this is going. I don't think this is where it is going now. I think a lot of firms are trying to engage in a reflection of, like, their how to build a better product. And I think the products are really getting better. Really. Based on our research, I think there's a lot. I'm very optimistic that we can build an open source community to knowledge engineer that knowledge in some ways, to engineer that knowledge in some capacity. Obviously, stuff that are private, we need to also make sure that it gets protected and so on. So from a product development and performance standpoint, I think also from an impact assessment, I haven't mentioned, I'm trying to do a lot of a randomized control trial. There is evidence that it is going to help low resource organization to deliver better justice. I think it's going to take a bit of time to integrate. It's going to take a bit of time to deploy, but we're getting there. Okay, so that's really on the both the performance and the impact on justice and clients. Another, so now when it comes to the future of the profession and lawyers, I know there's like, oh, lawyers are going to be disappearing. I don't think so, and I don't see why. I don't see how. I just see how complex law is, and a lot of the kind of garbage a lot of these tools are yielding. I mean, are generating. I don't see how this is happening. But you could argue, okay, yes, it's only going to get better. True, but I still see a role. So this is where I'm not really. This is a little bit outside of my expertise. The future of it's more of a job for labor economists to determine how jobs are going to be impacted. I don't see a decrease in hiring from law firm. I see an evolution in how they are going to be practicing law. I think we're not going to be delivering a service now. We're going to be building products, and I think this is a good thing. I think this is not a bad thing for lawyers. They have to also almost productize their service. But at the same time, yes, we must be cautious and there's no regulation against that. It's the fact that a lot of people are just treating themselves with GPT, and there a lot of them are also going to court with GPT. I think apparently the biggest use case for GPT is the therapy, and we know that there have been a few issues. So I think this is where I'm more concerned. Where how do we why do we not regulate? I mean, we should be able to regulate that in some ways, but there's no, it's not possible to implement a full ban. So I think the only solution is really to make that knowledge a higher quality so that people don't really just walk away with a lot of garbage information.
Yeah. Okay. Thank you.
You're welcome.
David.
Yes, thank you for your presentation. It was very informative. I just have a small question. Do you find the lack of regulation, I'm pointing to the fact that, remember ADA, the fact there's no law regulating AI in Canada plays a big role here, or you don't think it's really pertinent in your view? Thank you.
I mean, it is not really my main area of knowledge or expertise, so I'm going to be very cautious here. I did work for the EU for 5 years, so I know a little bit about EU regulation, including AI Act and GDPR. So, which is great. It's a great achievement. So I don't know if the fact that Canada doesn't have a similar piece of regulation is problematic in the sense that Canada is very much aligned with the EU when it comes to compliance with GDPR and AI Act, because if company wants to operate in Europe, they have to be compliant. Considering, and especially considering the given context, many Canadian companies will want to work in Europe. They will have to be compliant anyway. So the cost um of being compliant in Europe is already so high that it's a huge incentive to be compliant and in Canada too. So I don't think this is necessarily a bad thing that from a practical standpoint, I would call this like a law in action because eventually Canadians are going to be protected thanks to the European, it's called the Brussels effect. Okay. So when it comes like per se to the detail of the regulation, I'm not familiar with the substance. So I can't really say much whether, Canada should be doing more and whether it's stifling innovation and so on. I really don't think that's the case. I mean, a lot of European deep tech companies are growing. I mean, this year, even 80 university spin-offs have raised a lot of money. I mean, many of them have achieved unicorn status. So I don't think this is this creating the fact that there is an EU Act is creating. So Canada, if they had an ADA, it wouldn't hurt that much. But the fact that they don't have an ADA, I don't think it hurts that much because they're complying with the European standards anyway. Many of them are.
Perfect. Thank you very much.
Does anyone else have some questions or comments or thoughts?
I always have more if somebody else wants to go first.
Well, look, I think Samuel's given us 10 more minutes, so
Yeah, I've got time. Yeah. Yeah. Got a
Okay.
hard stop at one, but I'm good.
All right. Well, I'll jump in then. So in the Bay Area, San Francisco area, many years ago, there was a program called the Community Boards Program.
Hmm.
And basically, these were neighbors who were acting as adjudicators or more like facilitators for dispute resolution. And you mentioned that dispute resolution is a great big chunk of this, and also it's an access to justice problem. So the thing about the community board program is that it focused on collaborative problem solving. So it was not legal in the normal sense of the word, not arbitration or even mediation, because it focused on getting agreement by both parties. So there was no enforcement of here is the resolution, the solution. Uh, and I think that, there are other systems now, larger tools like Polis and make.org and whatnot that are trying to deal with dispute resolution on even societal or inter-country kinds of issues, including even war. or threats of war. So I'm just thinking that none of these things are primarily legal reasoning, but they are very much dispute resolution. And so there's a whole kind of school of thought around that. And I'm wondering, where you see the possible intersection here. And one other thing I'll just mention real quick is that there are also pieces of this problem that very focused systems have picked off, like parking ticket or traffic ticket resolution. There's a system, I can't remember the name of it,
Oh, there are a few, yeah.
yeah, those kinds of systems out there
Yeah.
too. So anyway, what do you think?
Yes, so I think you're referring to the ODR, the online dispute resolution, like the parking tickets. So there are quite a few. I think this one are more, I mean, rule based. So it's different. But the collaborative, regarding your collaborative dispute resolution, so what we call also in the ADR, so our alternative dispute resolution space, interest-based, so they mostly looking at the interest of the parties rather than right-based, which is more about, finding who is right and who is wrong and whose right has been violated. So so we're trying to integrate these into this project. And I think legal reasoning is a bit of an oversimplification. I'm trying, this is the umbrella term, and also my legal bias as a law, as a law professor and a lawyer, trying to see everything from legal lens. But I think a lot of people in the ADR field would sort of disagree with me and be like, oh, not really, that's not really law. We should split it. I still think that law has a monopoly of on resolving conflict, okay? Whether it's a good one, it's a bad one, it's different, it's a different question. But at the same time, it's a monopoly, but it's a monopoly for very certain types of dispute, considering the volume. Because even if you think about the volume, I was saying like 90% of 95, 98. I mean, personal injury is like 99, really. Like nothing goes to court. Okay. In Canada, I don't know about the US, but Canada. And so we shouldn't be calling this alternative dispute resolution. I mean, a lot of people have been saying this should be dispute resolution. But I think these should be integrated into this, I mean, some form of legal reasoning, because legal reasoning operates as as an objective criteria to evaluate the quality of an agreement. So yes, it's great. Yeah, okay, collaborative. I mean, I have this debate with a lot of my colleagues. Okay, collaborative agreements are very important. It's all about solving the interests of the parties, but interests are important, but interest needs to matter in light of objective data. It could be census, it could be law. So I think I see this as an ecosystem that have to sort of live together. Otherwise, we end up with a system. Otherwise, I think there's a real struggle on evaluation, and you need, even if the law doesn't necessarily mean a decision is going to be fair or aligned with the interests of the parties, law is still a relevant objective criteria that's shared by a lot of the parties. So it should be integrated, I think. So what I'm trying to achieve with some of the firm is that how can we give them output that shows what others have negotiated in the past, because it has value. It's a precedential value, but it doesn't mean like it's not a legal precedent, but at the same time also showing them the legal precedent. And how do you give them the more fulsome picture of how a dispute can be resolved? And then after, it's up to them to cherry pick and to arbitrate between, what is the best decision and what serves my client best. Because from a plaintiff side or from a defendant side, is obviously the argument is going to be very, what's good is going to be very different. So I think to answer your, I mean, the only comment I have is legal reasoning is probably the less accurate term, but it's an umbrella term that we chose to sort of capture everything related to dispute resolution, even if sometimes it's not legal.
Well, Samuel, thank you very much. This was a really good talk. And this is something that I think we should try and get more speakers on. Because I think it's relatively unexplored for this group, so I'm really grateful for the contribution. Yeah, seeing some clapping hands in the chat. Okay, everyone, that was great. Again, Sam, thank you so much. We'll stay in touch. Everyone,
Yeah,
thank you
yeah.
for your attention, and I'll see you soon.
My pleasure. Have a wonderful weekend, everyone. Bye. Bye,
Well,
Jeff. Bye,
thank you.
Chantal.
Thanks.
Bye, everyone.
Okay, take care, folks.